Convention, number 105, concerning the abolition of forced labor, done at Geneva on the 25th of June 1957, entry into force, the 17th of January 1959. Preamble. The General Conference of the International Labour Organization, having been convened at Geneva by the governing body of the International Labour Office, and having met in its 40th session on the 5th of June 1957, and having considered the question of forced labor, which is the fourth item on the agenda of the session, and having noted the provisions of the Forced Labor Convention, 1930, and having noted that the Slavery Convention, 1926, provides that all necessary measures shall be taken to prevent compulsory or forced labor from developing into conditions analogous to slavery, and that the Supplementary Convention on the Abolition of Slavery, the Slave Trade and Institutions and Practices Similar to Slavery, 1956, provides for the complete abolition of debt bondage and serfdom, and having noted that the Protection of Wages Convention, 1949, provides that wages shall be paid regularly and prohibits methods of payment which deprive the worker of a genuine possibility of terminating his employment, and having decided upon the adoption of further proposals with regard to the abolition of certain forms of forced or compulsory labor constituting a violation of the rights of man referred to in the Charter of the United Nations and enunciated by the Universal Declaration of Human Rights, and having determined that these proposals shall take the form of an international convention, adopts this 25th day of June of the year 1957 the following convention, which may be cited as the Abolition of Forced Labor Convention, 1957, Article 1. Each member of the International Labour Organization which ratifies this convention undertakes to suppress and not to make use of any form of forced or compulsory labor, a. as a means of political coercion or education, or as a punishment for holding or expressing political views or views ideologically opposed to the established political, social or economic system. B. As a method of mobilizing and using labor for purposes of economic development. C. As a means of labor discipline. D. As a punishment for having participated in strikes. E. As a means of racial, social, national or religious discrimination. Article 2. Each member of the International Labour Organization which ratifies this convention undertakes to take effective measures to secure an immediate and complete abolition of forced or compulsory labor as specified in Article 1 of this convention. Article 3. The formal ratifications of this convention shall be communicated to the Director General of the International Labour Office for registration. Article 4. 1. This convention shall be binding only upon those members of the International Labour Organization whose ratifications have been registered with the Director General. 2. It shall come into force 12 months after the date on which the ratifications of 2 members have been registered with the Director General. 3. Thereafter, this convention shall come into force for any member 12 months after the date on which its ratification has been registered. Article 5. 1. A member which has ratified this convention may denounce it after the expiration of 10 years from the date on which the convention first comes into force, by an act communicated to the Director General of the International Labour Office for registration. Such denunciation shall not take effect until 1 year after the date on which it is registered. 2. Each member which has ratified this convention and which does not, within the year following the expiration of the period of 10 years mentioned in the preceding paragraph, exercise the right of denunciation provided for in this article, will be bound for another period of 10 years and, thereafter, may denounce this convention at the expiration of each period of 10 years under the terms provided for in this article. Article 6. 1. The Director General of the International Labour Office shall notify all members of the International Labour Organization of the registration of all ratifications and denunciations communicated to him by the members of the organization. 2. When notifying the members of the organization of the registration of the second ratification communicated to him, the Director General shall draw the attention of the members of the organization to the date upon which the convention will come into force. Article 7. The Director General of the International Labour Office shall communicate to the Secretary General of the United Nations for registration in accordance with Article 102 of the Charter of the United Nations full particulars of all ratifications and acts of denunciation registered by him in accordance with the provisions of the preceding articles. Article 8. At such times as it may consider necessary, the governing body of the International Labour Office shall present to the General Conference a report on the working of this convention and shall examine the desirability of placing on the agenda of the conference the question of its revision in whole or in part. Article 9. 1. Should the conference adopt a new convention revising this convention in whole or in part, then, unless the new convention otherwise provides, a. The ratification by a member of the new revising convention shall ipso jure involve the immediate denunciation of this convention, notwithstanding the provisions of Article 5 above, if and when the new revising convention shall have come into force. B. As from the date when the new revising convention comes into force, this convention shall cease to be open to ratification by the members. 2. This convention shall in any case remain in force in its actual form and content for those members which have ratified it but have not ratified their revising convention. Article 10. The English and French versions of the text of this convention are equally authoritative.